President.
Attorney General.
Thank you, Madam Chair. Madam President, forgive me. I beg to move that a bill entitled An Act to Amend the Retiring Allowances Legislative Services Act, Chapter 203, the Prime Minister's Pensions Act, Chapter 251, and the Judges' Salaries and Pensions Act, Chapter 602, be now read a second time. Madam President, there is before us quite a simple piece of law. It strikes a few questions in law, but permit me to at least anticipate some of the arguments that may come this way in piloting the rationale for disturbing the Senate at 9:46 p.m. It seems fortuitous that we took a stretch of our legs and a small human break because we've managed to lose a few of our contributors who are surely still stretching legs. But Madam President, the bill before us is simply 4 clauses long, including the short title. We propose amendments to the 3 individual pieces of law: the Retiring Allowances Legislative Services Act, the Prime Minister's Pensions Act, the Judges' Salaries and Pensions Act. And in it, we seek to amend Act number 13 of 2019. Act number 13 of 2019 was certainly that recent piece of law, the miscellaneous provisions, tax amnesty, pensions, national insurance, central bank, companies, and non-profit organizations act. It was by that particular act, number 13 of 2019, which became law on the 25th of June 2019 by way of assent of Her Excellency the President. It is by that act of Parliament that we saw this legislature, this Senate, and this House of Representatives agree to, in an omnibus bill, one aspect of pension reformulation. Specifically, we saw the amendment of the pensions arrangements for legislators, for the judges, and for prime ministers, and for presidents. What we did, Madam President, in Act number 13 of 2019 is that we effectively recognized a pool of individuals who are not on equal footing with the rest of pensionable persons. And permit me to put that on the record. First of all, the category of people who are receiving a pensions adjustment that this bill seeks to cause, in Act number 13 of 2019, those people, prime ministers, presidents, members of the legislature, and judges, they are members of a contribution-type pension arrangement. In other words, then, 6% of their salaries go towards the contribution towards their pensions. That is not the case of contributions on the basis of the regular public service. Secondly, persons in qualifying, certainly as legislators, for this provision have to serve in a ministerial or viewed to be ministerial capacity, House of Representatives or minister in the Senate for a full period of 5 years before they can qualify. And secondly, they have to have paid their 6% contribution per month of their regular salary aspects. This is a very small group of individuals, and this group of individuals is certainly something that does not have the benefits that the regular public service has. And that regular public service arrangement is, of course, where through collective bargaining and other processes, the salaries are raised from time to time and different structures. The question is obviously going to be, when is now going to be appropriate? Fortunately, a Parliament took that decision earlier last month, and Act number 13 of 2019 was born by way of assent. Madam President, what happened upon assent, contemporaneous with assent, there was a question raised as to whether this package of amendments to a category of persons would allow people who had retired already to fall into the benefit zone. Secondly, the question arose as to what that benefit would actually be. Is that benefit properly one which entitles someone to an entrenched benefit, a vested right, if I put it that way, upon proclamation, where you would be entitled to what one would call traditionally back pay? Does a person who qualify as a retired legislator, as a retired judge, as a retired prime minister, as a retired president, does that person fall to be in the category of persons who, with a vested right upon assent, could allege that there's back pay that is payable? The third issue which arose is, when does the time clock start? And that's the crux of the amendment that we bring here today. That issue is, in looking at when the time clock starts, in Parliament recognizing by way of the amendments taken at the committee stage in the House of Representatives and in the Senate, in looking at that time clock, does a retired judge have to wait a full 5 years before the judge's pension kicks in as reformulated? If, for instance, the 3 judges who most recently left the bench in the last year fall into that particular category, must they wait 4 years and 9 months or 4 years and 10 months before they would be entitled to the current pensionable arrangements agreed to by the Parliament? In that particular circumstance, it is a matter of record which we are compelled to clarify today, consequent upon the interpretation principles set out in the very well-known case of Pepper and Hart. And for the record, I read that into the record. Pepper, who is the Inspector of Taxes, versus Hart and related appeals. It's 1993, 1 All England Reports at page 42, House of Lords decision, which dealt with statutory construction and Hansard and references to proceedings in Parliament as an aid to construction. Ambiguous or obscure legislation, whether a court may look at parliamentary history of legislation or Hansard as an aid to interpretation, whether the use of Hansard contravenes the Bill of Rights, whether the use of Hansard breach of parliamentary privilege, whether a Bill of Rights 1688 as it was there in England would have been infringed otherwise. Coming out of Pepper and Hart effectively was the classic case now which provides us with the remedy of solving what ambiguities in legislation look like. And effectively, we must now condescend to a few specific issues. First of all, do we have a constitutional issue in treating with this particular law, such as to invoke a 3/5 right consideration? That is, of course, hinged upon whether there has been a vested right in anyone who is the subject of a benefit under this law exercising that right. And then secondly, is this law one which has run afoul of an ambiguity as it relates to retrospectivity? And if we're treating with retrospectivity, what class and circumstance of retrospectivity are we arranged in? Forgive me for being rather technical, but I'm doing so in view of the fact that one could be challenged, and therefore as Attorney General and the mover of this legislation, I'm being, how should I say, purposefully legal in my contribution tonight. So, Madam President, when we look to the position of the law as it passed on the last occasion, it was open to ambiguity. It was open to ambiguity because the Parliament specifically included the fact that retired legislators, retired judges, retired prime ministers, and retired presidents could stand to benefit from the law of reformulated pensions. Secondly, as a matter of record, the Minister of Finance, in moving the debate, in dealing with the wrap-up, and certainly in my contribution as Attorney General, we made it abundantly clear that we were not asking for a retroactivity as it related to back pay. We did say that the law would apply axiomatically to all retired persons. Why? Because the law is, if you look at the name of the law itself, we're talking about retiring allowances. We're talking about the Retiring Allowances of Legislative Service Act. We're looking at the Prime Minister's Pension Act and Judges' Salary and Pensions Act. And when one speaks about retiring benefits and pensions, we're clearly speaking about entitlements to retired persons. The mischief which the Parliament was treating with in Act number 13 of 2019 was the very sincere and genuine complaint of Chief Justices and parliamentarians and other persons that the RPI index, as it has changed over time, eroded the ability of those persons to look after themselves. There was the unique circumstance, obviously, of the prescription against, for instance, legal practice, a 10-year prohibition period for practice at the bar for judges, and therefore that one could not find oneself into a different position. Madam President, when we look to Section 6B of the review of retiring allowances, if we look at the Retiring Allowances Legislative Services Act, Chapter 203, we look at Section 4A of the Prime Minister's Pension Act, we look at the provisions coming into Section 11A of the Judges' Salaries and Pensions Act. All of these things now include a retired legislator, a retired prime minister, and a retired judge. When we look to this arguability of whether the pensionable back pay entitlements come, the government considered that it was appropriate, out of an abundance of caution, to return to the Parliament the very next day after proclamation, after assent. We considered it appropriate immediately to come to the Parliament to cure what we thought could be an ambiguity which could be open to abuse. We moved the House of Representatives. We now come to the Senate. We caused the amendments which came at the committee stage from the House of Representatives to be before us now. But we have recognized that there is a problem that we need to also treat, and we intend to circulate amendments to treat with that. It is a small amendment which we want to add to this bill. This bill proposes, specifically as is before us here, to do surgery by adding in qualifying provisions to Retiring Allowances Legislative Services, Prime Minister's Pensions Act, Judges' Salaries and Pensions Act. And what we're saying here is that for the avoidance of doubt, subsection 1 shall not be construed as authorizing the payment of a revised retiring allowance with respect to a 5th anniversary which occurred before the coming into force of that section. What does that mean in the iterations between the judges, the persons in the legislature, and in the prime ministers? It means that there will be no back pay. What will happen is that you will be entitled, after the proclamation of the law, only to a prospective entitlement to the adjusted retiring benefit. That is the pension as reset and as it includes the housing allowance. No back pay. So Clause 2, Clause 3, and Clause 4 of the bill are effectively the no back pay provisions. That is what was moved at the committee stage in the House of Representatives in the bill as it now comes from the House of Representatives. Madam President, what has come onto our attention radar is the issue of whether a person who has in fact retired is entitled to this benefit, and if that person must wait a full 5 years. So, being a retired person now, clarifying in this bill that you're not entitled to back pay, there's one further mischief that has been spotted in the period between the House and now, and that mischief is, what about persons who are desperately in need of the reset? And I'll call a name here, forgive me, Madam President. I'm calling this circumstance of the Honorable Mr. Retired Justice, Mr. Justice Clinton Bernard, retired Justice, Chief Justice as he was, in the circumstance of a significant problem of an honorable gentleman who has served our country having to wait 4 years before his clock is reset. And in those circumstances, it is necessary for us to consider the immediacy of the reset. We propose, therefore, Madam President, to circulate a list of amendments asking for a qualification to subsection 1. Subsection 1 is where you say retired benefits apply. Subsection 2 is this bill where we're saying no back pay. Subsection 3, we propose be added in a list of amendments which we'll circulate, and we propose that we have very express language which says, notwithstanding subsection 1, a person referred to in that subsection who ceased to hold office before 25th of June 2019, that's the date in which the law became operative, is entitled to the revised retiring allowance referred to in that subsection as of June 25th, 2019, and thereafter on every 5th anniversary referred to in that subsection.
Simple.
So we are starting the clock for the revised benefit as at June 25th, 2019. Let's join just very quickly. I'm sure that there's going to be a question on constitutionality, so let me deal with this up front. Let's look at the position of whether we have a constitutional issue to be addressed. The constitutional issue is, of course, whether we are potentially depriving someone of a right to property without due process, contrary to Section 4A of the Constitution. The question in law is whether there would have been a vested right. And that question certainly is something which has to be addressed by the following facts. First of all, Parliament, in operationalizing the law as at June 25th, immediately moved to amend the law. Secondly, the payment of revised allowances is something that we have attended to in very express language. We certainly believe that we did not vest a right with immediacy. We believe that we are definitely capable of looking at the fact, firstly, that the law in its prospective application only would vest a right upon retiring benefits coming into effect. Laws must be interpreted to be applied as prospective in application. That is a statutory principle laid out in Bennion. That is the essence of the common law rule stated by Sir Owen Dixon, C.J. and Maxwell Murphy. It is also the statement coming from Lord Chief Justice Wolfe in Wainwright versus Home Office. That latter case is 2002 Queen's Bench at 1334, and the former case, that is the Maxwell case, is to be found at 1957-96 CLR at 261. We put on the record as a matter of interpretation, as it will come into aid, that the relevant provisions as introduced by Parliament were clearly prospective. They did not contemplate the payment of arrears. It is for that reason that we brought the bill in the form that we have, as is set out in clauses 2, 3, and 4. Secondly, in amending the relevant provisions, there was no express intention to alter prospective nature. Thirdly, since the relevant provisions are ambiguous, insofar as one could make that allegation, or make an allegation that they're open to construction, either prospectively or retrospectively, there is no necessary and distinct implication from language used. Indeed, I point to the statements of the Minister of Finance, relying upon the rule in Pepper and Hart, that it was never the intention of Parliament that there should be any vesting of rights in that purpose. Fourthly, we believe that the relevant provisions can be construed in accordance with the presumption against retrospectivity to apply to retired persons without imposing on the government any liability to pay arrears, and that's treating with the substance of the clauses of the bill itself, which treat with the concept of back pay. And fifthly, since the relevant provisions could be argued to be ambiguous because of some retrospective argument, the retrospectivity of the relevant provisions should be kept as narrow a compass as will accord with the legislative intention. And therefore, consequently, the relevant provisions should be regarded as applying to persons who retire before they came into force, but not to the extent of imposing on the government a liability of having to pay arrears. Madam President, We do certainly believe that the Parliament did have an alternate remedy. The Parliament could certainly, in the case of the Retiring Allowances Legislative Services Act, have relied upon regulations. Regulation 14 allows for the laying of regulations to treat with this very purpose, but it would have to have been done by way of an affirmative resolution. In other words, then a full movement of the Parliament to affirm the regulations. And secondly, Section 16 of the Judges' Salaries and Pensions Act also makes provisions for the use of regulations. But we thought it more prudent and certainly a better use of parliamentary time to move the Parliament in an act of Parliament, a bill to cause an act to be reviewed, as opposed to relying upon an affirmative resolution route for the legislature or the regulatory route for judges and their pensions. And in that purpose, in one fell swoop, relying upon the 5 grounds that I've identified, we think that this is opposite to the best interest of Parliament and to the use of the Parliament's time. Madam President, the essence of the bill is simply to treat with, as set out in the clauses that I have described, in clauses 2, 3, and 4, no back pay. We don't need to treat with the positions for the President because that law takes care of that. That is abundantly clear. That's why we've not treated with the President. We propose in the amendments which we will circulate that we add in a subsection 3 into each of those 3 pieces of law. The subsection 3 says that persons will be entitled as at the date when the law came into effect, and that is at the 25th of June 2019, and that they will not have to wait 5 years or any period thereunder to wait for their clock to be reset. Madam President, that is the rationale for these amendments, and I beg to move.
Honourable Senators, I shall now propose the question for debate. The question is that a bill entitled An Act to Amend the Retiring Allowances Legislative Service Act, Chapter 203, the Prime Minister's Pension Act, Chapter 251, and the Judges' Salaries and Pensions Act, Chapter 602, be now read a second time. Senator Mark.
Thank you very much. Madam President, more haste, less speed. I think that we are in a state of utter confusion after that presentation by the Honorable Attorney General. Madam President, we don't have the amendments before us except from what the Attorney General has uttered. So we cannot make sense of those amendments, properly speaking. We need to have some very serious clarification on this matter. Madam President, the government does not know what it is doing. The government is totally confused, and it is really taking decisions on the fly, on the hoof. Madam President, I would like to let you know very early, and I wouldn't like the Attorney General to be interrupting me, but I'll ask him to take notes. Madam President, we are being asked at 10:09, 14 seconds into this evening, into the night, to amend for a second time, in fact, almost for a third time, 3 pieces of legislation: the Retiring Allowances Legislative Service Act, the Prime Minister's Pensions Act, and the Judges' Salaries and Pension Act. What are we being called upon to amend? What we have before us is in clause 2, clause 3, and clause 4. And we are told in this piece of legislation that is before us. So if we go to the Retiring Allowances Legislative Service Act, we are being asked in 2B, subsection 2, for the avoidance of doubt, subsection 1 shall not be construed as authorizing the payment of a revised retiring allowance with respect to a fifth anniversary which occurred before the coming into force of that subsection. And that applies, Madam President, Prime Minister, and the judges. What we are being told by the Attorney General is that to avoid any challenge in another place, the government is seeking to make it abundantly clear that there is no retroactivity and by extension no back pay for those categories that are stated in the legislation before us. Now, what we are also being told, and is not clear, is that the Attorney General almost said, without prejudice, that the retiring judges, for example, who this government cried crocodile tears for, they will no longer be entitled, according to the Attorney General, Madam President, to any kind of back pay. What the Attorney General has said, and he can correct me when he's winding up, is that they are going back, but he didn't tell us how far back. Because to satisfy the needs of the retired judges, like former Chief Justice Clinton Bernard, the Attorney General is saying, Madam President, using the new definition of salary, which would include housing allowance, that upon the computation of that, the retired judges, including the Chief Justice, the former Chief Justice, Clinton Bernard, would be given, for instance, their new pension. And only that. What the Attorney General didn't tell this Honorable Senate is, where are we going? How far back are we going to those retired judges? Madam President, what is even more disturbing is this. I was the Minister of Public Administration and Information in the UNC administration under Bas Diopande. I lasted for 5 years.
5.
And Madam President, let me bring to your attention that during the period when I served as the Minister of Public Administration and Information, the SRC, as we deal with judges, provided super great quarters for all judges, including Clinton Bernard.
I'm not sure, please, I'm not sure about the relevance of what you're raising that point with respect to what we are dealing with here. Okay, I'm not sure, you're not convincing me, but as you continue, but just be aware of that, please.
Madam President, what I'm trying to clarify is this. it was the Attorney General who mentioned the name Clinton Bernard. And I'm telling this Honorable Senate that the retired Chief Justice Clinton Bernard was never entitled to a housing allowance. So, Madam President, if, for instance, the pension of this retired judge, as an example, is going to be based on the new definition of salary that would include the housing allowance for purposes of pension, how would the Parliament be able to satisfy the needs of the former Chief Justice when he never received a housing allowance? That is the point I'm making.
No, but Senator Mark,
Yes.
that point, unless I am mistaken, would have been relevant to the initial debate that we had when the amendment bill was passed. That point, therefore, is not relevant to what we are treating with today. You are, in essence, please, members, you are, in essence, reviving the debate that was concluded last month. So I'm going to ask you, please, to now take my guidance and deal with the matter at hand.
Madam President, we are being asked this evening to agree to a set of amendments that were just circulated. I am operating on the basis of what was told, what was said to us. What the Attorney General said to us is that this Senate is being asked to qualify and to make a further amendment to the amendment that we have before us. And he was taking into account, Madam President, those retired judges who he claimed were crying out and they would be left out given the current amendment that we have before us, subject to the latest one that was put on the table. I am simply arguing, Madam President, and submitting.
Mark, you are indeed arguing. There is absolutely no need to argue. Could you just, yes, thank you.
I'm just submitting, I'm just submitting for your consideration, Madam President, that it is not a simple matter that we are being called upon to deliberate and to debate this afternoon. We are being asked, Madam President, and given the information that was given to us this evening, we are not too sure how those retired judges are going to benefit from what the Honorable Attorney General has advanced. And Madam President, may I also ask whether the retired legislators, like former Minister Trevor Sudama, former Minister Overon Padmore, as examples, former Parliamentary Secretary Eddie Hart, as examples, would these former legislators who were ministers or held some capacity in previous administrations, how will the amendment being proposed by the Attorney General benefit those individuals? Because, Madam President, before the Attorney General introduced those new amendments, what we had before us is simply an amendment that said that there'll be no retroactive payment whatsoever for retired judges, retired legislators, prime ministers. But because of some kind of sympathy and sensitivity that was recognized belatedly by the government, we are now being told that an amendment has been made to the legislation, Madam President. Madam President, Madam President. Madam President, hear what it says. It says that we are to insert the following subsection. Notwithstanding subsection 1, a person referred to in that subsection who ceased to hold office before the 25th of June 2019 is entitled to the revised retiring allowance referred to in that subsection as of the 25th of June 2019, and thereafter on every 5th anniversary referred to in that subsection. Madam President, what I'm trying to find out, how will former judges who never received a housing allowance, Madam President, I am asking the question, how will they benefit from the measure in terms of the amendment? Because it is not clear, Madam President. It is not clear how they will benefit. I am saying, Madam President, we seem to be back to square one, where the government is attempting to bring some kind of measure of relief to judges and I guess retired legislators. But I'm not seeing, Madam President, in the amendment that is being proposed, how that is going to benefit those individuals, particularly, as I said, I am concerned about the retired judges. And I want to see how this is going to benefit them. Madam President, I remember very clearly when this matter was being addressed, that every attempt was being made to ensure, the government was ensuring or attempting to ensure that those categories of judges would benefit from the amendments. The category of legislators would also benefit. But how is this? The Attorney General, Madam President, has to explain to this Senate when is this particular measure that would impact on the judges and those legislators, because as well as former prime ministers, because, Madam President, I'm seeing where it is the three categories that are now being covered. But what we are not seeing in the legislation, Madam President, is that information that would guide us as to when the technicians would be able to say, listen, when would this thing take effect, Madam President? When is this going to take effect? This is not clear in the amendment that is before this Honorable Senate. And I am asking, Madam President, that the Attorney General would need to clarify these issues for us, because the Attorney General said it is clear that everything is going to be prospective. We are not going retrospective or retroactive. There will be no back pay involved, Madam President. That is what we are being told. And the question is, Madam President, is this measure going to generate some kind of discrimination? Can, for instance, the government, through this measure, guarantee that somebody will not take them to court in terms of what is being proposed here? Because, Madam President, I want to tell you, and this Honorable Senate, and I agree with you, I'm not going back to debate. But when you go back and you study, Madam President, what was the commitment given to the judges, what commitment was given to the retired legislators, what commitment was given to former prime ministers, you will realize, Madam President, what we are debating tonight is very far, and it deviates from the commitment given to the Senate and to those judges and legislators and former prime ministers to what is being put here tonight. You, the Honorable, the government, I'm not dealing with the Attorney General, the government, Madam President, in the exercise made it very clear that they were not going retroactive. You said so. But now you come with an amendment to say you're going retroactive, but the only difference, Madam President, Madam President,
Mark, I'm very reluctant to interrupt you, but it seems to me that you have gone as far as you can with your presentation, but you're starting to repeat a lot of what you were saying earlier in the presentation. So I need you to, please, if you have new points to raise them, else bring your conclusion, your presentation to an end, please, because you're starting to repeat continuously.
Madam President, you know, no. I have to take a deep breath because, you know, I don't want to run afoul of anything, right? And I don't want to argue with anybody. So I'll just take a deep breath. Yeah. But, Madam President, I am just seeking, and I'll take your guidance, we are just trying to get clarification on this matter. So I will call on the Attorney General when he's wrapping up to clarify a few points for us. First of all, Madam President, I'm seeking clarification as it relates to the following. How will Mr. Clinton Bernard benefit from these amendments when Mr. Clinton Bernard was never the recipient of a housing allowance? I would like him to clear the air on that. I would like him to also clear the air, Madam President, on how far back are we going to address the issue of retired judges. I would like him to also indicate, Madam President, when he's winding up, whether those individuals who are retired legislators and former prime ministers, how far back are we going with them in the context of what is being proposed? And Madam President, I believe that we need clarity of language in the proposed legislation so that there'll be no further amendments, there'll be no further confusion, and we will not be called upon to engage in another debate on amendment to a piece of legislation that we have exhausted, Madam President. So, Madam President, with these few words, I want to thank you very much.
Senator Vieira.
Thank you. Madam President, I have to say this amendment has me very confused. Let me start off by saying I'm confining my contribution only to the retired judges. Again, it's a small group of persons who have given many years of faithful and dedicated service to the country of Trinidad and Tobago. The act that we are looking to amend, which is Act 13 of 2019, at Section 11A says, a person, including a retired judge, is eligible on every 5th anniversary of the date he ceased to be a judge for a revised pension. Now, we know, because this was before us not so long ago, that this is now law. Act 13 of 2019 was assented to on the 25th of June. We are now saying, for the avoidance of doubt, subsection 1 shall not be construed as authorizing the payment of a revised pension with respect to a 5th anniversary, which occurred before the coming into force of that subsection. Now, what I'm not sure is, are we clarifying something but not changing anything, or are we making a change to rectify an inadvertent error? It's a big difference, because the Honorable Attorney General did ask, do we have a constitutional issue? Is there a vested right? Are we treating with retrospectivity? Well, I would say yes, because if this law was passed and the judges were given salary and pension benefits, the Constitution speaks to the point. And so what I'm going to suggest is, if a vested right was made, we can't unring that bell, because we're going to be caught in a constitutional box. There are special provisions that apply when you deal with judges. Section 133 of the Constitution says, under pensions, subject to Section 134, the law applicable to any benefits to which this section applies shall, in relation to any person who has been granted or who is eligible for the grant of such benefits, be that in force on the relevant date or any later law that is not less favorable to that person. So this 2019 Act is a later law, and if that law took effect, we can't come now and do anything that makes it less favorable. That's my interpretation of 133. And Section 136.6, tenure of special offices. And again, judges are regarded, the president, the chief justice, judges are special offices. The salary and allowances payable to the holder of any office to which subsection 1 and subsections 3 to 11 apply, or an office referred to in subsections 13 to 16, and his other terms of service, shall not be altered to his disadvantage after his appointment and for the purposes of this subsection, insofar as the terms of service of any person depend upon the option of that person. The terms for which he opts shall be taken to be more advantageous to him than for any other terms for which he might have opted. So again, once we made law and we gave them the benefit, I don't think that we can unring it. So the question is, the AG has said the clock starts on the 25th of June 2019, but that's not what my understanding of 11A was saying. I thought that he was eligible on every 5th anniversary of the date he ceased to be a judge for a revised pension, and that makes sense because there has to be a baseline. The baseline is when you retire, and then every 5 years, we can't come now and say we're not talking about from when you retired every 5 years. It's only going to kick in on the 25th of June, 2009. So again, I think we have to look very carefully not to be offending the provisions in the Constitution. And on the subject of retrospectivity, you know, I like to quote Benyon on statutory interpretation. He says, it is important to grasp, this is Benyon on Interpretation, 6th edition, page 293. It is important to grasp the true nature of objectionable retrospectivity, which is that the legal effect of an act or omission is retroactively altered by a later change in the law. However, the mere fact that a change is operative with regard to past events does not mean that it is objectionably retrospective. Changes relating to the past are objectionable only if they alter the legal nature of a past act or omission in itself. A change in the law is not objectionable merely because it takes note that a past event has happened and bases new legal consequences upon it. Well, the past event was that the judges retired, and they are entitled to those benefits that we have given them recently. So when the Honorable Attorney General said that retrospectivity should be narrow, I interpreted that as a concession, that some retrospective effect was in fact intended. And as I say, the mere fact that a change is operative with regard to past events does not mean that objectionably it is retrospective. So Honorable AG, through you, Madam President, I don't have the answer, but what I would say is we should proceed very carefully not to run afoul of the special provisions in the Constitution to protect judges and their tenure and their benefits. I thank you.
Attorney General.
Thank you, Madam President. Madam President, I thank Senator Vieira for his contribution. I think that he's, again, hit the nail on the head. I was compelled to listen to Senator Mark, and I noted that Senator Mark really drove home his point, because I think he repeated each one of his points, his 3 points, maybe 9 or 10 times each, probably to underscore the importance of his advocacy in those particular points. So let me not be pejorative in describing Senator Mark's passion. So let's start with the contribution of Senator Vieira, because that's really the gravamen of this issue. And permit me, Madam President, to grab a hold of the argument. Senator Vieira's submission, which I think is as lucid as all of his submissions are, and I'm not trying to butter you up, Senator Vieira, but thank you for your reflective consideration of the law. It really does genuinely help me personally as an attorney and as an attorney general to have the shared minds of many of my learned colleagues present, and I thank you profusely for the contribution. I'd like to say this. The submission that Senator Vieira offered was bifurcated. And Senator Vieira went on to say that it is an important point and a material difference between the two things which are bifurcated. Are we clarifying an issue, or are we correcting an error? And then Senator Vieira's inquiry really went along the latter route as to, are we correcting an error? And then as a position on the law which took us to the Constitution, took us to an interpretation of Section 11 of the judge's position, which can be replicated in respect of the other categories of persons I accept. But I thank you for confining it. But that submission went along the line of accepting that if it is an error, let's be careful. Let me state that the government's position is to hang the government's hat on the first limb. We are of the firm view, based upon what was stated in the debate, what was piloted by the mover of the bill, which was the Minister of Finance, what was the wrap-up in 2 houses of Parliament, that it was always the government's intention that the retiring benefits were to apply to persons who had retired but would become effective upon the date on which the law became effective. We believe, in keeping with the rule in Pepper and Hart, as accepted by the world of the Commonwealth, that we are drawing aid from the following factors. One, it was stated on the record that we intended no back pay, that it was always going to be, as the Hansard will reflect, that the benefit would be, on the date when the law comes into effect, persons who were suffering would be able to take advantage of an improved pension go forward. And to answer Senator Mark's position, because it relates to some of what Senator Vieira said, that improved pension would be what the salary of a current judge is and what the housing allowance of a current judge is. So the fact that Mr. Justice Bernard did not have a housing allowance is irrelevant, because it is the terms and conditions of a present judge who has a housing benefit that is relevant. Because if you accept Senator Mark's question, repeated over and over and over and over again, then you could stop at the fact that the judge had a lesser salary. How could Mr. Justice Bernard get a greater salary if all he had was a lesser salary? It's the same thing as saying, how could he get a housing benefit if he didn't have one? Because lesser and zero are 2 versions of lesser. So I'm just dealing in the very simple way of answering Senator Mark's submission. Having said on the Hansard record that we intended as the government in passing the law, and it was passed, that we would be going forward in the application of the law, the issue as to whether the law was ambiguous, such as to allow the latter limb in a different way to come into effect, the other limb to come into effect, that is, was it intended, is it open to interpretation that the judge who retired 40 years ago could apply for 40 years of 5-year resets? I retired 40 years ago, I retired 20 years ago. If I retired 20 years ago, do I have 4 periods of reset? And what we say is, on the second limb of our argument, the first one is Pepper and Hart, we were clear it is prospective. On the second limb of our argument, we say Bennion, Maxwell, and Wainwright all say general rule of statutory interpretation is that it is prospective. The general rule of statutory interpretation is only disturbed if there's an express intention that you ought to disturb it. That was upheld by the locus classicus, which is the case of Lienage, coming out of Belize. It was upheld in our Court of Appeal, and certainly in the Privy Council in the case of Northern Construction, where the issue of retrospectivity in Section 34 vested rights was considered. And the Court of Appeal and the Privy Council in the Northern Construction case were pellucidly clear that there was no disturbance of retrospectivity. There's a subset argument to that. In Senator Vieira's quoting of Benion's 6th edition, we're speaking about an objectionable retrospectivity. In this instance, I classify the argument as a non-objectionable retrospectivity, because we're not applying a prejudice. In effect, we're applying a benefit. And if I were to now turn to distinguishing the argument of sections 133, 134, and 136 of the Constitution, we're not derogating from terms and conditions of a sitting judge. We are seeking to clarify, not correct, the retiring benefits of a judge. And those retiring benefits are not pursuant to the SRC. They're pursuant to a standalone piece of legislation, and that legislation is the retiring judges' pensions and benefits legislation. And because Parliament and the framers of our Constitution and our Crown Colony, I dare say, prior to Constitution, said, if you're going to change pension for judges, for people who are in the Parliament, for the President or the Prime Minister, do that by an act of Parliament. Parliament, decide for yourself. No SRC, no trade union, no cabinet decision. The Parliament must decide that on a simple majority basis, because it's not special majority law. It is not entrenched into law. And therefore that puts a distinction on the caution on the second limb that Senator Vieira offered, at least from my perspective, most respectfully, through you, Madam President. Now, it's necessary if I'm treating with the issue of a vested right. If there's a vested right, so we say we're clarifying, we say Hansard says that, we say Pepper and Hart says that, we say Benion says that, we say Maxwell says that, we say Wainwright says that, the latter two being cases. We say, in any event, now we're falling upon the arguments offered in Northern Construction in the Privy Council. We acted immediately. We didn't wait a year, we didn't wait 6 months. We came quickly upon deciding an issue that there was something that needed to be clarified. And that was the subject of a significant amount of debate in the Privy Council and certainly in the High Court and in the Court of Appeal in Trinidad and Tobago as to Section 34 in its very unholy form coming into existence and then being repealed. So we've complied with Northern Construction, Privy Council, Court of Appeal, High Court. We've acted with alacrity. The other thing that we have done is we have certainly said, and this comes out of the case law, that when you're weighing factors as to whether the retrospectivity goes, if it's ambiguous, take the narrowest course of interpretation. And that's what I meant by the narrow compass. And that comes from the language of the case law itself. But in any event, if we're wrong, it's going to be tested. Certainly in the Northern Construction case, even though the repeal of Section 34 was done with a 3/5 majority, it was done on a unanimous basis. Even though that was the case, the Court of Appeal and the Privy Council also looked at the points of separation of powers, they looked at the point of rule of law, they looked at the point of retrospectivity, they looked at the point of vested rights, and in any event, these not being Section 4 and Section 5 rights, certainly, and that it being distinguishable that we're not messing, excuse the French, we're not interfering with 133, 134, and 136 of the Constitution for current judges' terms and conditions, my respectful argument is that we are not tripping any entrenched provision which requires special majority consideration. And if we're wrong, I hang the government's hat in my obligation to do so upon Baroness Hale's dicta in entrenched provisions not always necessitating 3/5 majority consideration. or if it's a deeper level of entrenchment, perhaps that. That has been upheld. We heard it today in Barry Francis and Roger Hines, etc. So, in summary, the government's position is that there are no vested rights. We are clarifying the law as it has become the law by Act number 13 of 2019. Why was the Act proclaimed? The Act was proclaimed because we couldn't amend a bill. And there was no proclamation clause. And I would say the Minister of Finance refused to accept my advice to put in a proclamation clause. He has since confessed mea culpa, and he says, next time I'll listen to your AG. I said, next time I'll be a little bit more forceful with you. But my initial intention was to put a proclamation clause, to do it in stages if they need be. But we had to proclaim the law because the law couldn't be amended unless it was an act of Parliament. And there is no proclamation clause which would allow you to amend an act which is not yet in operation. So we amended the law, we proclaimed the law, we move quickly, we're clarifying, no vested right, no 3/5 majority consideration from our respectful point of view, and we think that if and when this matter is tested, if someone chooses to test it, as is their constitutional right to do so, then we will argue that in court, and that is why we've said all of this on the floor of the Parliament, on the Hansard record, so that we can exercise the privilege of a petition, as we saw at the beginning of today's session, to get a certified extract of the Hansard, and then argue pepper and heart and constitutional remedies. Madam President, I beg to move.
Honourable Senators, the question is that a bill entitled An Act to Amend the Retiring Allowances Legislative Service Act, Chapter 203, the Prime Minister's Pensions Act, Chapter 251, and the Judges' Salaries and Pensions Act, Chapter 602, be now read a second time. Those in favour say aye. Aye. Those against say no. I think the ayes have it.
A bill entitled An Act to Amend the Retiring Allowances Legislative Service Act, Chapter 203, the Prime Minister's Pensions Act, Chapter 251, and the Judges' Salaries and Pensions Act, Chapter 602.
Attorney General.
Madam President, in accordance with Standing Order 66-1, I beg to move that a bill entitled An Act to Amend the Retiring Allowances Legislative Services Act, Chapter 203, the Prime Minister's Pensions Act, Chapter 251, and the Judges' Salaries and Pensions Act, Chapter 602, be committed to a committee of the whole Senate forthwith to be considered clause by clause.
Senators, the question is that a bill entitled An Act to Amend the Retiring Allowances Legislative Service Act, Chapter 203, the Prime Minister's Pensions Act, Chapter 251, and the Judges' Salaries and Pensions Act, Chapter 602, be committed to a committee of the whole Senate forthwith to be considered clause by clause. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The Senate shall now go into committee of the whole to consider the bill clause by clause.
Clause 1.
The question is that Clause 1 stand part of the bill. The question is that Clause 1 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clause 1 now stands part of the bill.
Clause 2.
The question is that Clause 2 stand part of the bill. Attorney General, there is an amendment circulated.
Yes, please, Madam Chair, should it please you. The government proposes effectively in the amendments to Clause 2 that we add in a third paragraph a new subsection 3, which would make it abundantly clear that the entitlement will vest for all persons who have retired. The point at which the clock is reset will be for all people at June 25th, 2019, being the date that the law was assented to and became operational. That means that all persons who were left in retirement in the state and condition where they were with inadequate pensions will all have their 50-year clock start on June 25th and therefore have a harmonized cycle go forward. That's the essential element inside of here, which we thought would take care of the staccato effect of people having to wait for periods of time which may be longer than they have left on God's earth. Thank you.
Honourable Senators, the question is that Clause 2 be amended as circulated. Those in favour say aye. Aye. Those against say no.
No.
I think the ayes have it. Honourable Senator, the question is that Clause 2 as amended now stand part of the bill. Those in favour say aye. Aye. Those against say no.
No.
I think the ayes have it. Clause 2 as amended now stands part of the bill.
Clause 3.
The question is that Clause 3 stand part of the bill. Attorney General.
Madam Chair, we propose, for the same reasons offered in causing the amendments to Clause 2, that we effectively do the same measure in respect of the legislation which governs the Prime Minister's pensions. That is the Prime Minister's Pensions Act, and that is the rationale standing for it.
Honourable Senators, the question is that Clause 3 be amended as circulated. Those in favour say aye. Aye. Those against say no.
No.
I think the ayes have it. Honourable Senators, the question is that Clause 3 as amended now stand part of the bill. Those in favour say aye. Aye. Those against say no.
No.
I think the ayes have it. Clause 3 as amended now stands part of the bill.
Clause 4.
The question is that Clause 4 stand part of the bill. Attorney General.
Thank you, Madam Chair. Madam Chair, for the same reasons volunteered as the rationale for the amendments to Clauses 2 and 3, we adopt and confirm that those are the reasons for the amendments proposed to Clause 4.
Honourable Senators, the question is that Clause 4 be amended as circulated. Those in favour say aye. Aye. Those against say no.
No.
I think the ayes have it. Honourable Senators, the question is that Clause 4 as amended now stand part of the bill. Those in favour say aye. Aye. Those against say no.
No.
I think the ayes have it. Clause 4 as amended now stands part of the bill. Senators, the question is that the bill as amended be now reported to the Senate. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The bill as amended will now be reported to the Senate. General.
Madam President, I wish to report that a bill entitled An Act to Amend the Retiring Allowances Legislative Services Act, Chapter 203, the Prime Minister's Pensions Act, Chapter 251, and the Judges' Salaries and Pensions Act, Chapter 602, was considered in Committee of the Whole and approved with amendments. I now beg to move that the Senate agree with the committee's report.
Honourable Senators, the question is that this Senate agree with the committee's report on a bill entitled An Act to Amend the Retiring Allowances Legislative Service Act, Chapter 203, the Prime Minister's Pensions Act, Chapter 251, and the Judges' Salaries and Pensions Act, Chapter 602. Those in favour say aye. Aye. Those against say no.
No.
I think the ayes have it. Attorney General.
Madam President, I beg to move that a bill entitled An Act to Amend the Retiring Allowances Legislative Services Act, Chapter 203, the Prime Minister's Pensions Act, Chapter 251, and the Judges' Salaries and Pensions Act, Chapter 602, be read a third time and passed.
Honorable Senators, the question is that a bill entitled An Act to Amend the Retiring Allowances Legislative Service Act, Chapter 203, the Prime Minister's Pensions Act, Chapter 251, and the Judges' Salaries and Pensions Act, Chapter 602, be now read a third time and passed. Those in favor say aye. Aye. Those against say no.
No division.
Mr. Khan,
Yes.
Mrs. Gopi Schoon,
Yes.
Mrs. Batiste Primus,
Yes.
Mr. Rambarat,
Yes.
Mr. Sinanan,
Yes.
Mr. Hussain,
Yes.
Ms. West,
Yes.
Mr. LeHunt,
Yes.
Dr. Henry,
Yes.
Mr. Singh,
Yes.
Mr. De Freitas,
Yes.
Mr. Cummings, Mr. Dookie,
Yes.
Mr. Simonet,
Yes.
Mr. Young,
Yes.
Mr. Mark,
No.
Ms. Haynes,
No.
Ms. Amin,
No.
Mr. Saddam Hussein, Mr. Obika,
No.
Mr. Sobers, Mr. Richards,
Yes.
Mr. Vieira,
Yes.
Dr. Dial Singh,
Yes.
Ms. Dionarain,
Abstain.
Ms. C. Prasad,
Abstain.
Mr. Timal,
Yes.
Mrs. Tom Snai,
Aye.
Dr. Dylan Remy,
Yes.
Ms. Mututa,
Yes.
22, 5, 2, 2, yeah. Voted for, 5 voted against, and there were 2 abstentions.
Honorable Senators, the result of the division is as follows. 22 members voted for the bill, 5 members voted against, and 2 members abstained. The bill has therefore been passed.
A bill entitled An Act to Amend the Retiring Allowances Legislative Service Act, Chapter 203, the Prime Minister's Pensions Act, Chapter 251, and the Judges' Salaries and Pensions Act, Chapter 602.
Leader of Government Business.
Thank you very much, Madam President. Madam President, I beg to move that this Senate do now adjourn to a date to be fixed and to indicate that this is our last sitting before the recess, and I want to wish those of us who are having a recess an enjoyable recess.
Honorable Senators, before I put the question, I just want to remind all senators that Trinidad and Tobago's Parliament is hosting the 44th Annual Conference of the Caribbean, Americas, and the Atlantic region of the Commonwealth Parliamentary Association. All members should have received an invitation to the opening ceremony, which takes place on the 15th of July 2019. And I really do hope that we will see members coming out for that opening. So, Honorable Senators, the question is that this Senate do now adjourn to a date to be fixed. Those in favor say aye. Aye. Those against say no. I think the ayes have it. This Senate is now adjourned to a date to be fixed.